Docks Limited and the Spéville.
Yes, Mr.
It please your Ladyship, your Lordship. I appear for the appellant together with my friend Randa Sibulu, and the respondent is presented by my learned friend Evi Duval, who is assisted by Ms. Lakshmi Charita and Mr. Kavi Arya. Milady, my Lord, this is an appeal against the decision of the Supreme Court of Mauritius, quashing the findings of the industrial court whereby the plaintiff sought damages, compensation for unfair termination of his contract of employment. I believe that your Lordship and your Ladyship would be happy to note that myself and my friend have been able to come up with a common statement of fact and issues.
All right. Yes.
And secondly, I have conferred with my friend, and we would have hoped to think that we should be able to finish the matter before lunch, but that, of course, would depend on how things...
We thought you might.
Milady, there are 4 issues to be dealt with in this case, and I propose to address them in the order they are set out in the summary which have been approved by the parties. The first issue, my Lord, my Lady, is the following: whether the requirement in Section 32(1)(b)(1) of the Labour Act 1975 to show that the employer cannot in good faith take any other course than to dismiss the employee is distinct from whether there is a valid reason for dismissal. UDL's position is set out in its statement of case at paragraph 10 to 12. That is at pages 1218 to 1220 of the record. And I propose in the course of my address, my Lord, my Ladies, merely to summarize the position in the course of this address. This issue arises from the Supreme Court's, which I would call incorrect, acceptance of this respondent submission at page 791 of the record, where it is said that it is submitted that the learned magistrate committed a serious misdirection, since the issue as put by her obliterates the requirement that the employer who dismisses for alleged misconduct must also show that it could not in good faith take any other course. I would also like to refer your Lordship and Ladyship to the findings of the Supreme Court at page 792, where the Supreme Court said the following: as regards the first limb of the submission of Mr. Duval SC, in the absence of any specific pronouncement by the learned magistrate that she had considered whether the employer had in good faith no other course than to summarily dismiss Mr. de Spéville, it cannot be assumed that she did in fact consider this requirement set down in Section 32(1)(b)(1), and more importantly, whether in her view this requirement has been satisfied. Our submission to your Lordship and Ladyship is the following: that the Supreme Court was wrong to consider that there were 2 separate tests. The learned magistrate indeed did not dispute the fact that did not consider 2 separate tests. In her judgment, which is to be found at page 610 of the record, the learned magistrate puts the issue as follows.
I'm so sorry, can I have that page number again?
Page 610.
Thank you.
Line 38 below, milady. However, Section 32 of the Labour Act provides that no employer shall dismiss a worker unless he cannot in good faith take any other course. I stress the magistrate is referring to the section, and she goes on to say, moreover, the burden lies on the employer to establish that the dismissal of the employee on grounds of gross misconduct is justified, and it could not take any other course. This means that the employer has the burden to prove that the impugned acts of the employee amount to misconduct, footload, or grave, justifying his dismissal. The learned magistrate, my lord, my lady, went on to consider an extract from the case of R.L. Frère and Virasamy, which was quoted in the case of Saint-Hubert, which was heard by the board, and stated that in the light of the above extract, it is for this court to determine whether UDL had a valid reason to dismiss the plaintiff.
Mr. Persem, you have actually skipped the quote from R.L. Frère,
Yes.
which the magistrate seems to have relied on. Termination would only be unjustified where the employer has no valid reason at all to
Correct.
discontinue employing a worker. Now, correct me if I'm wrong, was R.L. Frère not looking at the 1963 ordinance rather than the 1975 Act?
That is correct, my lord, but it has been said in a number of cases that albeit that R.L. Frère was decided under the previous legislation, but the approach, the principle which had been enunciated in R.L. Frère was similarly applicable under the 1975 Act.
Are the words of the 1963 ordinance identical to those in the 1975 Act?
I wouldn't say, my lord, that they are identical, but there are a number of cases where it has been said that the principle in the two, under the two statutes are exactly the same.
Well, I think it might be rather dangerous for us to rely on R.L. Frère. Might have been rather dangerous for the magistrate to have relied on R.L. Frère. Termination would only be unjustified where the employer has no valid reason to discontinue employing a worker. It might be safer for us, and have been safer for her, to rely on Section 32(1)(b)(1).
My recollection of the statement with respect to the two legislation is that the 1975 Act merely consolidated the previous legislation, my lord, so that although the two legislation are not exactly worded the same way, nonetheless, the same principle applies.
Very well.
Now, at page 608 of the judgment, the magistrate said this: the court is of the view that the employer was fully entitled to consider that in his capacity as accountant, the plaintiff could not have made such mistake.
I'm sorry, which line was that?
Which line?
So sorry, I didn't catch which line it was, please.
It is page 608, line 8.
Thank you. Yes, that refers to prejudice, to damage to the company, which we know was a very big sum in this case, many
Indeed,
times.
we will come to this later.
The effect of damage.
That is indeed the case, my lady.
Yes, thank you.
Now, the magistrate then concluded at page 611 based 41, page 611, line 41, my lady, my lord, based on the appreciation of the facts by the court, as illustrated above, the state of our law and the position of the courts, there is no doubt that gross misconduct has been fully established and that UDL was fully justified to dismiss the plaintiff summarily. I need here to say this, that I referred your lordship, your ladyship, to what he said at page 608, but then the magistrate went on to consider that this charge of wrong computation did not stand alone. Together with the charge of miscomputation, there were also a number of other charges. My lord, my lady, the learned magistrate's approach and interpretation of section 32(1)(b)(1), in my humble view, is consistent with the approach which has been adopted by the board and the Mauritius court. In this respect, my lord, I would like to refer your lordship and your ladyship to the case of Outim and Société de Gérance de Montloisier, a case which was referred to in the case of Total, Mauritius Limited, and Abdul Rahman, 2015, which was the case which was heard before the Privy Council. Now, in the case of UTIM, can I just favour your lordship with the case of UTIM?
Is it not in the...
Is it not in the
It's
bundle?
not in the bundle. It's not in the bundle. I would like to direct your lordship and your ladyship to the penultimate page and the first paragraph of the judgment. Whatever be the law in France, Mr. Justice Glover, writing the judgment, said, our section 32 says that even if there is an act of misconduct, the court will look upon outright dismissal as unjustified.
Sorry, where do we find this?
Penultimate page, first paragraph, third line, my lady.
Which page?
Penultimate page?
Penultimate?
Yes.
There one.
Last
Yes, I got it.
Third line.
Penultimate page.
Yes, the ultimate page, you've got 2 lines.
I see. Yes?
Is your lordship, your ladyship with me?
No, I've not found it yet. Oh, it's the third line of what's basically the last page of the judgment.
Indeed.
Yes, thank you.
Now, it says, whatever be the law in France, our section 32 says that even if there is an act of misconduct, the courts will look upon outright dismissal as unjustified if either it intervenes well outside the prescribed time, which is not relevant, or the employer does not satisfy them that he could not in good faith have taken any other course. Obviously, the degree of misconduct is itself one of the factors to be taken into account to determine whether the employer can be expected to tighten the punishment or forego it altogether. I would also like to refer your lordship, your ladyship, to the case of Total Mauritius Limited, Abdul Rahman, at tab 2, page 1467 of the record. I'm reading from paragraph 23, my lord, of the judgment. It seems to follow, therefore, that as Mr. Suzy submitted to the board, an employee's faute grave is misconduct for which, within the meaning of section 32 1B1 of the Labour Act, the employer cannot in good faith take any other course than to dismiss, with the result that by virtue of section 35(1), he is not entitled to severance allowance. Your lordship, your ladyship will note the reference to the case of UTIM at paragraph 27. At paragraph 28, your lordship, your ladyship will note that the board considered a combination of 10 factors surrounding the circumstances of the employee's misconduct. And at paragraph 29, the judgment reads as follows. The board concludes that taken together, the 10 factors set out above render the breach of the employee's duty of non-competition so fundamental that even when placed in the context of his long unblemished record, it could not reasonably be regarded as other than faute grave. My submission, my lord, is that in the present case, the learned magistrate adopted exactly the same approach as the board did in the case of Total, in that the learned magistrate did not consider that valid reason, gross misconduct, and cannot in good faith take any other course, referred to different tests in section 32 1B. The learned magistrate looked at the circumstances of the misconduct altogether in order to determine that they amounted to misconduct. And these are, firstly, the fact that the employee, Mr. Spéville, was the number 2 of management of UDL. Secondly, UDL is a public listed company and shareholders are entitled to expect that the decision of the board of directors are not only accurately recorded, but those decisions are accurately implemented. Thirdly, the magistrate considered the seriousness of the mistake of a senior accountant as Mr. Spéville. I would like to refer your lordship to page 608 of the judgment of the learned magistrate. And then the court said this. Now, the court said that this charge does not stand alone. The other elements which the learned magistrate took into account was the fact that Mr. Spéville had been found to be aggressive towards the then general manager, Mr. Bissac, thus committing an act of insubordination. Secondly, that Mr. Spéville had slandered the directors of UDL by calling them fouilleurs de poubelle. Thirdly, Mr. Spéville questioned...
If he was going to go rummaging around to see who'd voted for what at the annual general meeting, that description is not entirely inapt, is it, Mr. Persem?
I believe the use of the term fouilleurs de poubelle was nonetheless somewhat harsh.
Yes, maybe.
Not to say rude vis-à-vis the
yes.
board of directors, my lord. Mr. Spéville questioned the propriety of the decision of the board to appoint an external auditor. Mr. Spéville disclosed certain confidential information to Mr. Rivalon after the latter's departure, and also the learned magistrate took the view that during his suspension, Mr. Spéville had visited the mailbox of Mr. Bissac, and he opened and read the emails of Mr. Bissac. And these are to be found, my lord, at page 608 and 609 of the judgment. Now, my submission to your lordship and your ladyship is this. Neither my learned friend nor did the Supreme Court cite any authority in support of the proposition that Section 32(1)(b)(1) provides for two separate tests. Tellingly, I said none is cited, as I said, by the respondent or the court. My submission to your lordship and your ladyship is this. The magistrate had asked herself the right question, whether the termination was valid, and for that matter, she considered not only the misconduct and other irregularities, but she also, in the exercise, considered whether the employer had any other course than to dismiss. My submission is therefore that when the Supreme Court comes to say that, look, she had not addressed her mind to the issue of whether the employer could not in good faith take any other course, my submission is that the Supreme Court erred in so saying. These are my submission on this issue.
The magistrate also looked at the prejudice. That's the point we stopped at before on page 608.
Yes.
That's a necessary element, isn't it? Because it's saying...
Indeed. Perhaps I overlooked that aspect.
Explain why I'm putting the point, because in order that the employer can consider whether there's any other course, he has to take into account the prejudice which he considers that the employee is presenting to the company, to the risk of damage to the company or the past damage. And that gives content to this requirement.
Indeed, milady, and I would like to say that the prejudice was not insignificant. It was quite significant.
Indeed, it was a significant sum in this case.
We'll come to the financial prejudice.
All right.
Now, I would like to move on to the second issue, my lord, milady. That relates to the payment of the severance allowance at normal rate. Now, the issue is this: whether applying Section 32(1)(b)(1), the fact that UDL paid severance allowance to Mr. Spéville at the normal rate meant that it could not in good faith take any other course than to dismiss the employee. This point, my lady, my lord, is addressed in some respect in paragraph 13 to 19 of the statement of case, although I would like to say that the issue is phrased slightly different way. I have had the benefit of the statement of case of my learned friend. I believe that the issue can be narrowed down to the following: whether UDL's payment of severance allowance at normal rate meant that its summary dismissal was unjustified. Now, the issue, my lord, arises from the conclusion that the Supreme Court arrived at page 792 of the record, line 11. So 792, line 11. In connection with the second limb of the submission of Mr. Duval SC, the plea of UDL and the findings of the learned magistrate that the payment of 1.1 million was on humanitarian ground fly in the face of the letter accompanying the payment, document AQ refers. The letter bears distinctly the heading payment of severance allowance, and Mr. Spéville is informed that notwithstanding that he had been found guilty of gross misconduct, he would be paid the sum of 1.1 million as severance allowance at the normal rate. In the light of the payment made and also of the concession of Mr. Bessac, we can only conclude that UDL has failed to prove that it summarily dismissed, when it summarily dismissed Mr. Spéville on the 21st of February 2007, it could not in good faith take any other course. The summary dismissal should therefore be deemed unjustified. To clarify, I agree with my learned friend's suggestion at paragraph 33 of his statement of case that before the Mauritius court, when we refer to summary dismissal, that means dismissal without notice and without payment of any compensation. That, I believe, we agree. Hence, the respondent question whether UDL's payment of severance allowance at the normal rate to the respondent 10 days after his dismissal meant that the dismissal without compensation was unjustified. Now, I have 2 points to make on this. Firstly, Section 36, subsection 7 of the Labour Act provides that severance allowance at the punitive rate is payable when termination was unjustified, not whether it was unjustified for the employer to dismiss without paying compensation. If we look at the précipé, the initiating process in this case, which is at page 10, paragraph 21 of the document, paragraph 21. The case of the plaintiff was, the plaintiff further avers that his employment was terminated without any cause, real or serious, and therefore amounted to unjustified dismissal. Not that the summary dismissal was allegedly unjustified. Nowhere in the plea does it mention summary dismissal being unjustified. Now, in its submission before the lower court, the respondent conflated the two issues which the Supreme Court, in my humble submission, wrongly accepted. In other words, the fact that it might have been unjustified to dismiss without any compensation does not mean, in my humble submission, that it was unjustified to dismiss the employer.
Well, the total case was all about whether summary or other dismissal was justified. It was not about whether the dismissal itself was unjustified.
Our point is that the Supreme Court seems to have addressed its mind merely to the fact that having paid the severance allowance at normal rate, did it mean that the summary termination was unjustified? The Supreme Court, in my humble submission, failed to proceed to consider whether the termination.
Well, the question is whether the dismissal
Indeed.
is unjustified.
Indeed.
The question as between summary and on notice dismissal is a separate question.
Correct.
That's the point I'm putting to you, and that was the point in total, because total is about whether it was summary or on notice dismissal.
That is indeed the case. I know that in the case of Total, I think the board referred to what is referred to as the conundrum with respect to termination with payment of normal severance allowance and
Yes.
summary termination. But the point I want to make here is that it was not sufficient that the court reached the conclusion that if there was payment of 1.1 million, there was the summary termination was unjustified. The court failed to address its minds to the other issue. Could the termination have been justified?
Mr. Persem, this question about the significance of the payment of ordinary rate.
Yes.
I think provisionally, I for my part would agree that it doesn't always follow from a payment at ordinary rate that there is any concession that the dismissal was unjustified. But you've got to look and see why the payment was made at ordinary rate. And Monsieur Baissac was asked about this.
Correct.
And if you've got page 1137 to hand, particularly line 22, I think we see an answer. I've got it in the English translation.
Yes.
1137, line 22.
Indeed, my lord.
Is this Monsieur Baissac answering a question?
Yes.
We can all call it an afterthought. We can say we looked into the file, and as the reasons I just raised, being given that our legal advisers has recommended us that there was no ground to dismiss him. Well, I'm not exactly sure of the legal term, but sometimes after we studied the case, we thought as a matter of goodwill, good faith, we'd pay him this amount. So there he is accepting that the payment was made because the legal advisers had said there's no ground to dismiss him. What do you say about that?
My lord, I think with respect to the Supreme Court made specific reference to this bit of the evidence. My submission is that it would be inappropriate to look at this extract in isolation, because I think it would be important for your lordship, your ladyship, to go to page 1099 of the record when Mr. Baissac is asked specifically with respect to the payment of the 1.1 million. Page 1099, line 27, my lord. Mr. Baissac explains why the payment of 1.1 was made to MDS. We thought, can I just read that part of his evidence?
Yes, certainly.
We thought we had all the elements to dismiss Mark without any compensation. But we said that nevertheless Mark had years of service before him. So we had taken all these in consideration. We thought that it would have been fair on our part to give him at least a compensation at normal rate. And this, what we did through. I don't know. Generosity, we felt it was a good thing to do. It was the right thing to do. Now, there's also the submission of Mr. Baissac at page 1137, line 7. That was under cross-examination. I repeat, page 1137, line 7. Of course, we were communicating with our legal advisors, and the legal advisors thought that the case was sufficiently serious to dismiss Mark of 20 years of service. We had thought that as a, I don't know what term it is, as a gesture of goodwill or whatever. So the management indeed had to consider giving Mark a severance allowance at normal rate to show the good faith of the management. That's the reason why it was done, and also a bit under the advice of the recommendation of our legal advisor. I perfectly agree with your lordship that Mr. Besak said what he said at page 1137, but I think it would be unfair to disregard what he had said. I think he had given an explanation of the circumstances which led the company to effect that payment. And I think it would be perhaps also important to go to the terms of the letter which was sent to Mr. Besak, Mr. Spéville, I'm sorry. That letter is to be found at page 644 of the record. The letter reads, "The management has further considered your case and has, in the light of your long years of service with the company, and also in a gesture of goodwill, decided to pay you severance allowance at normal rate in the sum of 1.1 million. And this, notwithstanding the fact that in view of the management, you have been guilty of gross misconduct." And we enclose a check. My submission is that perhaps I take what your lordship said earlier. The mere fact of having paid that compensation could not in itself render the serious misconduct lesser than what it was. So that my humble submission is that the mere fact that UDL ultimately paid that compensation couldn't mean that the gentleman had not committed serious misconduct. So there are 2 points which we'd like to make is, firstly, the court did not address its mind properly to section 36 in relation to this payment. And secondly, the mere fact that there was this payment in itself cannot be said that, look, the employer was wrong in terminating the employment, as he did. You know, I would like to move on to the third issue, which is perhaps the crux of the case in this case. It relates to the issue of computation, whether the termination of Mr. Spéville's employment by UDL was justified. This point is addressed in the statement of case at paragraph 20 to 28. I would like in the first place take your lordship, your ladyship, to page 637 of the record, where the charges are set out. The first one relates to the wrong computation, and the other charges, act of insubordination, the fact that he'd slandered the directors, he's put into question the propriety and soundness of the board's decision, he had disclosed confidential information pertaining to the company, he had accessed the email of the Mr. Besak in the course of his suspension, and there was a reset of the email password. Now, the wrong computation, as I said, would have it that the employer suffered prejudice to the extent of 7,675,215. As correctly observed by the Supreme Court, UDL's case is that charge number 1, whether on its own, and that is something which I said it before the learned magistrate, charge 1, whether on its own or along with other charges, justified summary termination. Now, there's one clarification which we need to perhaps bring. The learned magistrate correctly held that the charge leveled against Mr. Spéville was not that he had failed to consult the board resolution, but then ruled that this issue relates to charge 1, miscomputation. What is meant is that the failure, what the magistrate meant, was that the failure to consult the board resolution on its own does not amount to a charge. However, it was clear at the disciplinary committee, and in the light of the evidence given by Mr. Iralal at the DC, that the charge was that Mr. Spéville had wrongly computed the retirement benefit because his computation was not in accordance with the board.
Mr. Persem, are you going to address us on the fact that on page 607, line 17 of her judgment, the magistrate finds as a fact that in computing the payoff, the respondent relied on the words of the chairman of the board and the chairman of the relevant committee. Now, if they told him, look, take his total remuneration, please, not just salary.
Correct.
If they told him that, and he relied on it, and took total remuneration, how can you fit that finding into a charge of gross misconduct?
All right. Can we perhaps, my lord, to answer your question, go to the resolution of the board?
Certainly.
Which is at page 645. There were 4 elements. It says, les directeurs parlent de la demande de M. Rivalan de prendre sa retraite avant la prochaine Assemblée générale de la compagnie. Cette demande est acceptée. Il est décidé à l'unanimité de lui accorder une somme équivalente à 1 année de salaire comme ses prédécesseurs. This is the first item. 1 année de salaire comme ses prédécesseurs. Secondly, une pension complète. Full pension. And thirdly, ex gratia payment, ex gratia paiement d'un mois par année de service. Fourthly, the car. So we are not very much concerned with the full pension and the car. There were 2 items which were hotly disputed. That relates to 1 année de salaire, and secondly, the ex gratia payment of 1 month for each year of service. And it is to be noted that the board resolution doesn't say, it says ex gratia payment of 1 month for each year of service. Now, I think we need to take those 2 elements, 1 an de salaire and the ex gratia payment separately. The explanation of Mr. Spéville was that he had received instruction from the chairman of the board and the chairman of the corporate governance committee to pay salary plus benefit. His question, he said that at the request of Mr. Iralal, he was asked to produce a document testifying that, in fact, there were those instructions. The letter which he received from the chairman of the board and the chairman of the corporate governance committee ought to be found at 643. Now, that letter, my lord, deals purely and simply with the issue of ex gratia payment. Now, it seems to be that in relation with his decision to pay as regard un an de salaire, salary plus fringe benefit, could not be explained. There was no basis on which he could justify the payment of the salary and the fringe benefit to the extent that the instruction which he said he received was purely and simply in relation with the ex gratia payment. Now, I must say that Mr. Piat, chairman of the board, deposed before the court. Mr. Piat said that he clearly understood that there was a difference between salary and remuneration, whereby salary meant purely and simply salary, remuneration meant salary and fringe benefit. That was his evidence before the court. Mr. Iralal said, well, to the extent that the resolution spoke in terms of un an de salaire, I computed it purely and simply on the basis of the salary. The learned magistrate reached the conclusion that to the extent that it was said un an de salaire, basing herself on the evidence of Mr. Iralal, reached the conclusion that the respondent could not have paid more than purely and simply the salary. I will come to your lordship's question when it comes to the ex gratia payment, but what I wanted to make clear is that one needs to make a distinction between the salary, un an de salaire, and the ex gratia payment. I think it's important, perhaps, at this juncture, to go to the figures, my lord. Now, can I take your lordship, your ladyship, to page 656 of the record, where Mr. Iralal summarizes the discrepancy and gives us evidence of overpayment. Now, your lordship will see, is your lordship with me? Page 656. Mr. Iralal says 1 year salary, quantification of board decision. He mentioned the figure of 2,400,405, computed purely and simply on the basis of salary. If I may help your lordship will see that figure on page 655. Last column, basic salary, total 2,400,405. Is your lordship
Yes.
with me? Right. So, Mr. Iralal computed the 1 year salary, as I said, purely and simply on the basis of salaire, whereas the respondent computed un an de salaire, and he reached the figure of 4,854,600. Now, your lordship will find this figure on page 659. Yeah. Now, this is the computation which is done by the respondent. He reached this figure of 4,854,600. Now, top of the page, I'm still on page 659, your lordship will see that the basic salary, the total basic salary is 2,600,540. Now, this figure, your lordship will find it at page 657. Last column, first row, 2,600,540. Now, it is to be borne in mind that in computing this, the total basic salary, the respondent had included 13 months of payment as opposed to 12. So that was the first. There was not only the mistake in relation with respect to salaire and fringe benefit, but there was also the computation of the basic salary on the basis of 13 months. So if I come back, my lord, to the table of Mr. Iralal at page 656, Mr. Iralal reached the conclusion, therefore, that there would have been an overpayment of 2,454,195.
Well, that's all very well, Mr. Persem, but the charge was, look, an 8 million rupee overpayment, and the greater part of that was the ex gratia overpayment, yes, allegedly. And your problem about that is that in reference to the ex gratia payment, the respondent had precisely followed the instructions of the two chairmen.
Yes, my lord.
Very well.
Now, the first observation which I would like to make is that the learned magistrate reached the conclusion that, look, there was the resolution which the respondent said I had never seen. He said that I relied on the words of Mr. Platt and Mr. Spéville, who were the chairman of the board and the chairman of the Corporate Governance Committee. Now, ultimately, the point of the chairman of the board and the committee was that, look, you had to include salary plus remuneration. Mr. Iralal does not dispute that principle. What Mr. Iralal said was that one could only include those benefits which had been declared to the Income Tax Office. And you will see, my lord, your lordship will see this in the document which is at page 655, where your lordship will see Mr. Iralal computation of the ex gratia. Now, one needs to bear in mind one thing, my lord. One must not overlook, before we come to this issue of salary and fringe benefit, there was another, I'm sorry to use the blunder which the respondent committed, was that in computing the ex gratia, he again took 13 months as opposed to 12 months, and that is not disputed, but he also, in his computation, included an amount of 480,425. Your lordship will find this figure. If your lordship go to page 657, fifth column, the payment which is made in December 2005, there is what is referred to therein as a special allowance, which was in fact a back pay. Now, that is undisputed. It's agreed by the parties that not only did he include this amount, but he also computed the ex gratia on the basis of 13 months, with the consequence that that on its own caused an overpayment of nearly 2.5 million rupees.
Is there anywhere where Mr. Hiralal sets this out in narrative form, what he says the mistakes were, either in a written statement or in his evidence to the magistrate?
I believe that
I've certainly read a bit about the basic salary point.
but I'll try to find this evidence.
Thank you very much. The reference to his oral evidence and any written,
But
please.
what your ladyship should perhaps bear in mind, that at the very outset of the examination of the plaintiff by my learned friend Mr. Duval, that is something which he himself concedes that there has been, I'm trying to find the evidence, there has been, can I take your ladyship to page, 68, I'm reading from the French version.
68.
68. My learned friend is examining the plaintiff. Le premier, Midway, le premier désaccord était sur le, autant que je m'en souvienne, était sur que ça a été calculé sur 13 mois au lieu de 12 mois. Le deuxième désaccord était sur le ex-gratia fait à M. Rivalan. Et le troisième désaccord pense que c'était, il avait soulevé un point, octobre à octobre. Donc c'était 13 mois au lieu de 12 mois, oui. Et vous avez reconnu cette erreur. He admits that he committed a mistake. And then my learned friend questioned him. Il y a aussi un autre item qu'il avait dit, qu'il avait eu un paiement en décembre de la somme de 482 000, qui était un ajustement. Ça avait dû être mis, n'aurait pas dû être mis dans la calculation. It's not disputed. I'm sure my
It's still not disputed. Those matters are still not disputed.
It is not.
But it leaves the question of the basic salary or not question, and that's what I'd like to know where it features in the evidence, please.
Now, my point is this. When it comes to the ex-gratia, so there was the first set of mistake with respect to the 13-month and 12-month and the back pay. But when it comes to the inclusion of benefits, the divergence of views were the following. Mr. Hiralal said, look, I don't dispute the fact that benefits ought to be included, but the only benefit which could be included were those which were on his statement of emolument, which were reported to the Income Tax Office. Hence the reason why, to me, it was not appropriate to include all the other benefits. Now, the difference is set out at page 655, where your ladyship will see Mr. Hiralal including a car benefit, one vehicle, and ultimately the figure which he reached was taking the salary and the benefit of the use of one car was 11,509,749. Now, Mr. Hiralal Milady also did a computation. I mean, without the mistake, if I may say, had it not been for the mistake of 13 months and the back pay, and your ladyship will see this at page 658, where, in fairness to the respondent, I must say, to the extent that the respondent was right in including all the benefits which he did, then Mr. Hiralal said that the overpayment was 2,552,320. Hence the reason why we say that as a result of the mistake of 13 months and the back pay, there had been an overpayment of 2,552,320. So that when it comes to the question of computation, the learned magistrate firstly concluded that when it comes to un an de salaire, clearly accepted the evidence of Mr. Iralal, that one could not include the fringe benefit, with the result that there was an overpayment, as explained by Mr. Iralal, of 2,454,195. When it came to the ex gratia payment, there are two ways to look at it. Firstly, if the respondent had been right in including all the benefits, then nonetheless, as the table shows at page 658, there would have been an overpayment of 2,552,320. But of course, our submission is that the learned magistrate, having heard Mr. Iralal, reached the conclusion that clearly the respondent could not have included in the benefit those benefits which were not on the statement of emolument. And hence the reason why the learned magistrate reached the conclusion that there was a discrepancy of 4,871,020, which is on page 656. Now there is a third element which is addressed in the court below, that is the management fee. The management fee. Now, there was a management fee which was paid to Mr. Spéville at the point in time he left, there was a document.
Mr. Spéville or Mr. Rivalon?
Upon the departure of Mr. Rivalon.
Very well.
Right. Now, the case of UDL was that he could not have been paid 450,000 rupees in terms of management fee. The learned magistrate relied on the resolution of the Corporate Governance Committee. Can I just take your lordship to this resolution? Now, it all has to do, my lord, with management services which were being provided by United Dock to two different companies, MCFI, Mauritius Chemical Fertilizer Industry on one hand. Your lordship will find this document at page 660. And then there is the management services which were being provided by United Dock to RL Malak Company Limited. In relation to both companies, management services were being offered, and those companies were paying United Dock the sum of 50,000 rupees monthly. Now, there was this resolution. There is a resolution of the Corporate Governance Committee, which I'm trying to retrieve, whereby the latter had decided that 100,000 rupees would be paid to Mr. Michel Rivalon. Now, what the respondent did, he paid the whole amount which had been received up until the time Mr. Rivalon retired to him, whereas Mr. Iralal basing himself on the resolution of the Corporate Governance Committee, which said that 100,000 to be paid to Mr. Rivalon. Hence the divergence of views as regards the stand of UDL on one hand and the respondent on the other hand. Now, the learned magistrate reached the conclusion, and your Lordship, your Ladyship will see this in the judgment of the magistrate, that, if I can take your Lordship, your Ladyship, to that part of the judgment. (607), line 39. It starts line 30. As regard the management fee paid to Mr. Rivalan, the plaintiff once again stated that he was instructed to include the sum of 450,000 by his then GM, Mr. Rivalan himself. Mr. Bessac relied on the Corporate Governance Committee resolution, document AX, to maintain that only 100,000 was to be paid to Michel Rivalan. The plaintiff disagreed with this interpretation. He was told by Mr. Rivalan that that sum was payable on a monthly basis and had become payable prior to the actual signature of the agreement. Again, the court notes that a reading of this document does not show that this sum was payable to Mr. Rivalan on a monthly basis, or that the whole amount received by UDOL was payable to Mr. Rivalan. The court will rely on the principle of presumption of regularity to say that the minutes are to be considered a faithful reproduction of the intention of the directors of this listed company. Therefore, it has no hesitation in rejecting the version of Mr. Piat and Mr. Spéville on the issue. The court notes that the plaintiff did not avail himself of the official document before implementing this decision of the Corporate Governance Committee, but rather chose to rely on the words of the GM who was on his way out. So, as I said, there was a dispute with respect to this payment of the management fee. Ultimately, the court reached the conclusion that we had to go by the resolution of the Corporate Governance Committee. You know, that resolution, your Lordship, your Ladyship will find it at page 664.
While we're on 607, if it's convenient to you, Mr. Persem,
Yes,
could we just look at the paragraph above line 30?
Yes, my Lord.
You started reading at line 30.
Correct.
At the end of the preceding paragraph, the magistrate is saying that the respondent should have checked the resolution. He failed in his duties by failing to look at it. Had it been any part of your case before the magistrate that he had a duty to check the resolution?
That was the position which I took before the court below.
What was the position?
I.e. that he was under the duty to verify the resolution.
Was it your case before the magistrate that he had a duty to look at the resolution?
Indeed, my Lord.
It was?
It was. Now, since your Lordship has raised the issue, your Lordship would have noted that the Supreme Court felt that there was a shift in the position of UDL from purely and simply miscalculation, if I say wrong computation, to a charge, if I may use that term, of failing to consult the resolution. My submission is that the charge remained what it remained. It was the respondent response to the charge that, look, I have never looked at the resolution. So my response to him was that, well, if you had not looked at the resolution, you were even more negligent, because as an accountant number 2 of United Dock, occupying the position which you did, it was your duty to consult the resolution to see to it that you were implementing a proper decision of the board of directors.
And to complete the picture, was it any part of the company's case before the disciplinary committee that he should have looked at the resolution?
From my own recollection, it does not seem to me, my Lord, that the issue whether he had seen the resolution would have been raised.
Very well.
I must say that I'm relying on my memory of the events. I believe the first time he mentioned that he had not seen the resolution was before the industrial court, and this is why I said to him, well, if you did not see the resolution, then you had also failed in your duty, because as accountant, you ought to have consulted the
Thank you.
resolution. Now,
But the magistrate didn't believe him on that, did he?
but, in relation with the charge of wrong computation, I know it's not always convenient to go from one document to another. What we have done is we have prepared a table which tries to summarize the position with respect to what I have said. I believe that might be of some help to your lordship, and I have communicated a copy to my learned friend.
My understanding of the magistrate was that she took the view that if his explanation was that he hadn't looked at the resolution, that made matters worse, because that was even more negligent not to look at the resolution, rather than that she disbelieved him as to whether or not he'd looked at it. That's how I read what's said on 607. But
That indeed was the position of United Dock, and your leadership would have noted that the Supreme Court felt that, look, we were as if coming up with a new charge of which he was not faced with before the disciplinary committee. And my submission is that, no, that is not correct, because the charge remained the wrong computation.
The point my lady has just made is, I think, confirmed by 596, where the magistrate finds in the middle of the page, line 22, that he was aware that there was a board resolution regarding the computation of the benefit and never tried to obtain a copy of it.
That is. Now, my lord, can I move on to deal with the issue of whether the magistrate had failed to address her mind to the allegations of ill treatment? The Supreme Court's reproach on page 793, line 38, firstly, there
Sorry,
is...
Did you say
793, my lord.
Thank you.
Line 38.
line
38, I'm sorry.
13,
38.
38. Sorry.
38, I'm sorry.
No, thank you.
Firstly, there is, in our view, substance in the submission made by Counsel under Ground F that the learned magistrate erred in taking the view that the case of Mr. Spéville not being one of constructive dismissal, evidence of ill treatment allegedly meted to him should not be of any concern. The allegation of ill treatment were important and should have been given due consideration, since the case of Mr. Spéville was that UDL had trumped up false charges against him, and that the ill treatment was indicative of the fact that UDL was bent on getting rid of him. Now, can I take your lordship to the judgment of the learned magistrate at page 606? Line 39. Now, the court notes that the charges in the letter of charges were in no way a reaction to the ill treatment, to the alleged ill treatment of the plaintiff. Now, the learned magistrate considered, in my humble submission, all the allegations of the then plaintiff and found that none of those allegations were founded.
I think the case against you, if I can play devil's advocate just to test that proposition, the case against you is what she said at lines 31, 32, and 33 on this same page. The court sees no reason why it should even be concerned with whatever alleged ill treatment may have been meted out to the plaintiff.
Correct.
And so I think part of the case against you, Mr. Persem, is if she has put that all on one side and said, I'm not concerned with it, how could she then, 6 lines later, say the charges were in no way a reaction to the ill treatment? Because she hasn't looked at the ill treatment.
But isn't that because she prefaced the sentence that you've read out on the part of the sentence with the, unless the alleged ill treatment could justify the wrongdoings?
Indeed.
So she's saying they weren't in any way related. We could argue about that, actually. We could argue about the bin searching, couldn't we? And
yes.
We could argue about the challenging the bringing in the external auditor. They were really part of the whole picture of you're treating me badly, you're disrespecting me, and so on. So one could argue about that.
I think, what Mr. Spéville claimed was that, he was treated as being indésirable. The learned magistrate considered this. The learned magistrate considered the fact that, they had decided to change signatory of the check. And a number of the complaint. What I wanted to say is that the magistrate did not ignore those complaints which the respondent raised before her. But what she said was that, look, the case before me is not a case of constructive dismissal. So that in that respect, those complaints are of no concern, of course, unless those complaints justify the wrongdoing. But in any case, my submission is that she did address her mind to each and every complaint which the respondent raised. And ultimately, Your Lordship will see at page 610, she says, was not a sham. Just trying to find the line where she says
Line 15.
I think indeed, Your Lordship is right. 14th line. In addition, the plaintiff was of the opinion that the DC was a sham. The court does not uphold this view. There is enough evidence on record to show that the GM extensively relied on the help and collaboration of the plaintiff when he actually joined UDL. For instance, the plaintiff was part of the negotiation going on with UDL in the South Africa. Indeed, the new GM may have had his own way of doing things, but this in no way means that he had a hidden agenda. If he thought it wise to redistribute the counted task in the manner he did, he cannot be questioned, as it was within his inherent power. Now, what I'm saying is that there were certain complaints which were raised. These were considered by the magistrate to the extent that she said, look, it's not a case of misconduct. For that purpose, I need not worry myself about those complaints. But she did address her mind to the issue raised by the respondent. Were the charges a sham? So my submission, my Lord, is that to the extent that the Supreme Court reached the conclusion that the learned magistrate did not sufficiently consider the allegations of ill treatment, my humble submission is that the Supreme Court were wrong in so saying. Now, remains for me to deal with the last ground of appeal, which relates to the decision of the Supreme Court to pay interest, to order UDL to pay interest at 12% from the date of termination. We've dealt with this issue at paragraph 29 to 33 of our statement of case. Your Lordship, your Ladyship would note that it's a discretion which is given to the industrial court in appropriate cases. My submission to your Lordship, your Ladyship, is that it is a matter of regret that the Supreme Court did not motivate its decision to inflict the higher interest of 12%. I think the court, having decided to impose the higher rate of interest, it was the duty of the court to state the reason why it had decided
It doesn't say anything at all, does it? It just says with interest. 12%.
I believe I have covered...
Was there any articulated submission made from your side as to what, if the Supreme Court was going to go down that road, the interest rate ought to be?
From recollection, I would like to confess I don't think we did. Neither myself nor my learned friend.
You knew that the respondent was asking for 12%. He'd asked for that from day one.
That is correct. That is correct.
Is that correct?
He did. He did. I believe, let me just check the plate with summon, my lord. Yes, yes. At page 11, the plaintiff did ask for compensation together with interest at 12%, but as I said, the Supreme Court unfortunately did not invite submission on this issue.
When you got the written judgment from the Supreme Court, why didn't you write in to say, we note your provisional determination of 12%. We haven't actually argued that out. I wonder whether I might be allowed to be heard on this question.
The view which is taken, my lord, is that to the extent that the court has delivered its judgment, its functus officio, it would not perhaps have been appropriate to ask the judges to come up with the reason why. But I take your point whether on a future occasion we will have to do it.
I don't know enough about the sort of interest rates recoverable and payable for the local currency during this period to know whether somebody who lives in that country would think that was a penal rate or just a fairly commercial rate.
Perhaps to give an indication with respect to the difference between the normal legal rate which is applicable, I am advised that it used to be 8%. It's been amended. It's approximately in the region of 2.5%. Above. Sorry. It used to be 8%, but now it's 2.5%.
On judgment?
Above PLR.
Is that on judgments or?
On judgment.
Yes, that's what I thought you meant. So during the relevant period, it was probably still at the 8% rate?
Yes.
Yes.
Yes, that is correct.
As indeed it was here.
Now, there's one observation I would like to make. My learned friend, in his statement of case at paragraph 29 to 31, would have it that the Supreme Court found that Mr. Spéville had been deprived of his constitutional right to a fair trial by reason of the inordinate delay in delivering the judgment, and that accordingly ground 1D should succeed. I have had some difficulty because I can't recall the Supreme Court having reached this conclusion. At page 795, the Supreme Court makes an obiter comment to the effect that it has not received submission on this issue of delay, and it does not make any finding. So that my submission is that there was no finding by the Supreme Court that Mr. Spéville had been deprived of his constitutional right.
What about 794, lines 28 to 30?
My response to this is that, well, the court perhaps commented with respect to delay which might have had some impact in connection with the appreciation of the evidence, but the court did not go on to say that the respondent had been hence denied of his constitutional rights.
Well, if there hadn't been delay and the findings had been made correctly, he would have had his money much earlier. Isn't that the inference? Perhaps I've missed it.
Maybe that's the inference one can draw from the... Perhaps to end, can I just refer your lordship, your ladyship, to page 795, line 8. We did not have the benefit of argument on the point taken under ground 1, but the delay in the handing down of the judgment constituted a breach of the appellant's right to a hearing. Whether such a breach has taken place must be assessed in the light of the circumstances.
Yes, well, we read that, and that doesn't amount to a finding that there has been, clearly, but I take my lady's point. Anyway, there we are.
Milady, I have done. To sum up, my submission is that the Supreme Court firstly was erred in law in reaching the conclusion that the magistrate had not addressed her mind to this issue of whether, in good faith, the employer could not take any other course. Secondly, we say that the payment of the 1.1 million in itself cannot render determination unjustified. Thirdly, we're saying that in the light of the findings of the magistrate with respect to the computation being wrong as it did, the termination of the employment of the respondent was clearly justified, taken on its own or along with the other charges. And fourthly, as I said, the court was erred in law in not stating the reason why it had decided to impose interest at 12%.
Yeah. Thank you very much indeed, Mr. Percival.
Could I just follow up one factual point? You took us to the letter, document AP, which is the letter from the two chairmen, in which it mentions only the ex gratia payment.
Yes.
The evidence that the respondent was giving, though, was that he was told by the directors to work it out on the basis of everything that had been received during the year, wasn't it?
Correct. I've
been looking at page 140, 141. Can't quite remember where I found it there, but somewhere on those, around there. Oh yes, it's at the bottom of 141 and the very top of 142.
141, Monsieur Platt m'a demandé de préparer la
Yes.
computation de Monsieur Rivalan en prenant en considération tout ce qu'il a touché pendant la dernière année. Now, there seems to be some confusion, if I may say, in the mind of the respondent, because the respondent said, I had never seen the resolution. He said that I received the instruction from the chairman of the board and the chairman of the Corporate Governance Committee, and their saying is backed up by the letter. And I said the letter refers only, purely and simply, to the ex gratia payment.
Right, so the stages are that he said he hadn't seen the resolution, he got the information from the chairman said take everything that he was paid into account. It's backed up by the letter, says the respondent. You say, no, it isn't, it's just the ex gratia payment that's backed up. Is that the position? Okay.
Thank you.
Perhaps my attention is drawn to something he said at page 294, line 18, where I did question him with respect to document AP. I said, look at document letter AP, yes, it only concerns ex gratia payment.
This is the chairman giving evidence, isn't it? Well, it says here,
Yes.
your clarification, Mr. Piat.
That is Mr. Piat.
It's Mr. Piat.
Correct.
Yeah.
Sorry.
That's correct. That's indeed the case.
Thank you. Thank you very much indeed, Mr. Person. Mr. Nosimulu?
Malady, I have nothing to add to
Thank you.
this.
Thank you. Mr. Duval?
Indeed, my lords, as you would have gathered, I'm alone today, Ms. Charita and Mr. Arya having chosen to stay in Mauritius for obvious costs.
Well, for obvious reasons, yes, but we're delighted to have you with us.
There is no issue before the board of the Supreme Court misdirecting itself as to its role as an appellate court. In fact, many of the most important findings of the Supreme Court are hardly questioned, if at all. The appellant is asking the board to set aside the order of the Supreme Court and to restore the original order of the President of the Industrial Court when it itself does not support the main findings of the President. At trial, UDL's final submission was that there was no summary dismissal in this case. Despite this submission and the strong reaction that it provoked, the President found justification for summary dismissal in the alleged breach of duty of the accountant to personally verify board minutes when faced with instructions from the chairman of a board of directors and the chairman of a corporate governance. Before the board, UDL says the manner in which Mr. Spéville was dismissed is not material. UDL concedes that Mr. Spéville never had the opportunity before his disposal to explain why he did not verify the actual board resolution. But UDL says that it does not matter because it did not ground the dismissal on that particular reproach. We say that the board should not interfere with the judgment of the Supreme Court unless it is satisfied that the judges was plainly wrong in their criticism of the judgment of the President. We say that the Supreme Court was plainly right when it found that the President had erred in principle and made findings which were manifestly wrong. The upholding of grounds 1D and 1F of the grounds of appeal relating to the breach of Mr. Spéville's constitutional right to a fair hearing within a reasonable time is certainly the most severe criticism about the proceedings before the Industrial Court. We say, and I would like to take your ladyships and your lordships to page 7-9 of the brief at line 24.
79.
795.
795, forgive me.
Yes, I thought you'd said 79 as well.
Sorry.
795. Thank
Yeah.
you.
And I quote,
Yes.
"On the other hand, we note that the trial, which started on 17 June 2008, ended on 31st May 2011, after at least 11 sittings. The cross-examination of the plaintiff lasted over at least 3 sittings, and the transcript of his testimony, mainly under cross-examination, runs over 156 pages. The legitimate question to be asked is whether the trial could not have been conducted in a more efficient and effective manner, thus clarifying the issues to be determined and assisting the court to quickly resolve them," unquote. I note that the board has expressed doubt as to whether there was a finding that there was a breach of a constitutional right. I would like to take your lordships and my ladies to page 614, where you will find the grounds of appeal. Now, ground 1 reads as follows: "The inescapable inference to be drawn from the shortcomings of the judgment delivered on 20th June 2014 is that the delay of some 4 years in delivering the judgment amounts to a breach of the appellant's constitutional right to a fair hearing. Such shortcomings include the largely limited to," and then there is a list. Among them, there is 1D and 1F. If we go back, and I'm sorry to going back and forth, but if we go back to the judgment of the Supreme Court at page 792, at page 792, line 30, the Supreme Court is referring to the second point, which was about the opportunity to answer the charge. And according to the Supreme Court, that point was made under 1D. I read, "A second point is taken by Mr. Duval SC. The point does not fall under grounds 2 and 3. It would fall, in our view, under ground D, 1D. And then, if you look at the next page, 793, line 27, "In the light of a concession made by Mr. Persam and the findings of a learned magistrate, the second point taken by Mr. Duval should also succeed. So, ground 1D, which is about the breach of constitutional right, has succeeded in the view of the Supreme Court." And if I can take your ladies and your lordships to page 794, at line 32, we see grounds 1F, 2, 3, 5, and 6 having succeeded. So we have 2 subparagraphs of ground 1, which the court found to have succeeded. They both relate to the breach of the constitutional right to a fair hearing within reasonable time on account of the delay and the adverse effect it had on the capacity of a magistrate to evaluate the evidence. But most importantly, we note that the appellant does not dispute that the question whether the trial could have been conducted in a different manner was indeed legitimate. And because at trial, the burden rested squarely on the appellant to justify whatever it did, on the basis of what it knew or ought to have known at the time it did it, we note the significance of the appellant not even attempting to answer this question before the board. I propose to organize my response to my learned friend's oral case in 4 distinct, very short parts. Firstly, the manner in which the dismissal of Mr. de Spéville took place. Secondly, the operative reason for the dismissal of Mr. de Spéville. Thirdly, the principles of laws on which the Supreme Court relied to find that the summary dismissal should be deemed unjustified. And fourth and lastly, the exercise of the discretions of a court in awarding interest at 12%. Turning to the manner in which UDL dismissed Mr. de Spéville. Both the President and the Supreme Court found that UDL summarily dismissed Mr. de Spéville on 21st February 2017. That is document AN at page 668. It is disturbing that the President should have nothing to say about the significant shift in the case of UDL throughout this case, and at very least at trial, although much was made of it at submission. Now, if I can tax the board's patience by going to the record, but it is an unnecessary exercise, I'm afraid. At page 37, we have the plea of the appellant before the industrial court. It reads as follows. As regards paragraph 19 of the précipé, defendant avers that notwithstanding the fact that the plaintiff has been guilty of gross misconduct, defendant nonetheless paid to the plaintiff severance allowance on humanitarian grounds. Now, if we turn to page 38, paragraph 17, defendant denies the arguments contained in paragraph 22 of the précipé and avers that notwithstanding the fact that A, the plaintiff has committed an act of gross misconduct, B, the plaintiff was not entitled to any compensation, and C, the defendant suffered prejudice in the amount of $7,678,215 as a result of the gross misconduct of the plaintiff in respect of the retirement benefits allegedly paid to Mr. Ballon. The defendant has paid in all good faith the sum of 1.1 million to the plaintiff, unquote. So, as per the pleadings, this is a humanitarian gesture made in all good faith. Now, if we turn to page 87, we can feel that the wind is starting to change with the introduction of an alternative plea. And I hasten to add that this is 1 year after the plaint was lodged, after the case has started in front of a different bench and had to be started anew. So on the first day the case starts anew, the appellant moved to amend its plea, and if we look at line 24 at page 87, we Mr. Person, before my learner proceeds with his case, I would wish to make an amendment to the plea by adding the following. In new paragraph 17a, after paragraph 17 to read, defendant averred that in the alternative it was entitled to terminate the employment of the plaintiff on account of the fact that there had been loss of confidence as between plaintiff as employer and the defendant as employee and the defendant as employer. Now, unquote, not a word at this stage as to whether, when dismissed on such a ground, notice is payable. We are only talking here about the alternative. If We now turn to page 586. Which is the written submissions of the appellant before the trial court, the final written submissions. And I can take your ladies and the lordships to line 6. On 1st March, they decided to pay in something equivalent to what they say is a severance allowance, but that does not change the fact that it has been summarily dismissed. If I steal a pen, the fact that I gave it back eventually does not disrupt me. And I did steal a pen. And although I will offer submission of that particular part, I would like to say that I cannot understand how my friend can be here to say that he was not summarily dismissed, because eventually we gave equivalent of severance allowance. This is my reaction to the change at final submissions stage, that now this was no longer a case of summary dismissal. Now, if we now turn to page 686, which is the skeleton arguments before the Supreme Court. Paragraph 8. The respondent, and I quote, the respondent nevertheless paid the appellant the sum of 1.1 million, representing severance allowance at the normal rate. It is the respondent contention that such payment was made on humanitarian ground, notwithstanding the appellant misconduct. So we are now back after the trial to the stand that this is, after all, a summary dismissal, and we just paid an amount equivalent to severance allowance at the normal rate out of our good heart. Now, we must not forget that this is someone, an employer who says, you've cost me 7.6 million, this is unacceptable by any standard, you are therefore dismissed summarily, and then 10 days later sends a check of 1.1 million in the post. And what about the position of UDL before the board? If I may borrow an expression from my Lord, His Lordship Briggs, I am in a state of enduring puzzlement. If we look at page 1211, paragraph 3 of the case for the appellant, line 7, that charge either on its own or together with other charges leveled against Mr. de Spéville justify UDL's decision to terminate his employment. Mr. de Spéville was suspended pending the outcome of the district committee and was then dismissed with immediate effect, that is, summarily without notice. However, 10 days after the dismissal, UDL considered that it was appropriate to pay severance allowance at the normal rate. So here we have severance allowance at the normal rate was not humanitarian, it was appropriate. And if we turn to page 1219, and that is what explains my state of puzzlement, if we look at the note 7, note 7, it's a footnote, my ladies and lordships, line 3, in the present appeal, the issue of whether Mr. de Spéville's conduct amounted to a faute sérieuse or faute grave, I suppose that is the manner in which he was dismissed, would only be relevant to determine whether he was entitled to payment of wages in lieu of notice. If the board accepts that the dismissal of Mr. de Spéville was justified and therefore no severance allowance was payable, UDL submits that it will be unnecessary for the board to go further to consider whether wages in lieu of notice should have been paid to Mr. de Spéville, in the circumstances where he was paid a gratuity by UDL 10 days after his dismissal in an amount which far exceeds the wages in lieu of notice that might have been payable. The gratuity paid in consideration of his long years of service with UDL and was calculated on the basis of a severance allowance at the normal rate. So now, my lords, my ladies, we have another scenario. This is no more a case of summary dismissal and 10 days later a payment equivalent to normal rate. This is no more a case of dismissal upon payment of severance allowance. This is now a case of dismissal of some kind with a gratuity which is said to include notice and something else which is more or less tantamount to severance allowance at the normal rate. We invite the board to reject the argument that the manner in which Mr. de Spéville was dismissed has no relevance to the determination of whether he was entitled to severance allowance at the punitive rate. Now, my ladies, my lords, UDL relies on the case of Saint-Aubin, just like the Supreme Court did in the case of Grey Walls. This is in the bundle of authorities at 1346. Grey Walls, it has page 1337. The extract I'm looking at is at 1346. The last two paragraphs we read as follows. Before turning to the other grounds of appeal, the next question which arises at this juncture is what happens when constructive dismissal has been established. The learned magistrate proceeded to decide whether the charges establishing gross misconduct had been proved or not before finally deciding to order the appellant to pay severance allowance at a punitive rate. Such a course is being attacked by the appellant. One of the grounds being that the learned magistrate failed to consider or to give sufficient consideration to the appellant's alternative plea that severance allowance should only have been paid at the normal rate and not at the punitive rate. This is a subject of ground 4 of appeal. The issue has been authoritatively dealt with in the recent decision of a judicial committee in Saint-Aubin Limited versus de Spéville. Now, I will humbly submit that when the case of Grey Walls came to this honorable board, the board distinguished the case of Grey Walls by saying this was a case of constructive dismissal, it was not a case of gross misconduct. And we'll see that. So Grey Walls before the Judicial Committee of the Privy Council is to be found at 1384, it's tab 8, and if I may take my ladies and my lords to page 1389 paragraph 24, it was agreed.
Yes?
It was agreed before the board that far from advancing the argument now constructed, counsel then appearing for KSL told the Supreme Court that the correct approach to sovereign pay was to apply the principle enunciated in Caillou de Maroussem and Saint-Aubin Limité versus Alain Jean-François de Spéville. Neither was a misconduct case, and no point arose on Section 32A. These cases were concerned with when termination of a contract of employment was made a valid reason. Now, how we have this expression, valid reason, again. And the main argument of the appellant in regard to Section 31.2 is that this board should accept that when she said that there was a valid reason to dismiss, the President should be understood as having said both requirements of Section 32.1b have been satisfied. I beg to disagree. And my learned friend earlier said that he found no authority cited before the Supreme Court or accepted by the Supreme Court as to the proposition that there are two distinct requirements. Well, this is the case of Ragobir, Movillac versus Ragobir, and this is in the judgment of the Supreme Court. At page 791, line 10.
791.
791, the judgment of the Supreme Court, at line 10. I quote, as submitted by Mr. Duval, it is settled law that under the above provision, an employer should not dismiss an employee for alleged misconduct unless the two conditions set out at 1B1 and 2 have been satisfied. Conversely, if the two conditions were not satisfied, then the termination of the employment of the employer would be unjustified. See Movillac Industries versus Movillac 2006. 2006, yes. And it is, of course, in the bundle. We say that it is necessary to distinguish between two case scenarios. Firstly, an employer who, in good faith, dismisses an employee summarily and then is unable to satisfy the industrial court that the misconduct on which the dismissal was grounded was tantamount to a footload, that is so serious that it would outweigh all other consideration and would justify depriving the employee of notice and of severance allowance at the normal pay. That is one scenario. And the second scenario is the one in which we find ourselves. An employer who summarily dismisses an employee and then has an afterthought and decides to consider whether in the circumstances it would not be appropriate to pay severance allowance at the normal rate. And of course you have a concession before the Supreme Court that severance allowance at the normal rate is always accompanied by notice. And you would have realized, my lords and my ladies, that the appellant has nothing to say about what happened to notice in this case. In the first case scenario, the sanction is notice plus severance allowance at the normal rate. In the second case scenario, the sanction is notice plus severance allowance at the punitive rate, and that is because the requirement of Section 32(1)B Roman 1 has not been satisfied. It is at the time that the dismissal happens that the employer must make out its mind. Do I consider that this misconduct is of a nature that after having considered everything else, be it his record, be it his length of service, I cannot do anything else but to dismiss summarily. Now, it is my humble submission that it is for UDL to justify what it actually did and not what it could have done. On 21st February 2007, it summarily dismissed Mr. de Spéville. And so it was upon UDL to satisfy the president that it had no other alternative to do so. Citing Meuvillac and Ragobia again, the proposition there was that it would be illegitimate to allow an employer to avoid the consequence of his contravention by inquiring as to whether it was justified to dismiss upon payment of notice and severance allowance at the normal rate. As we have seen, UDL is unable to describe what it actually did, let alone to justify it.
Sorry, in this case, you're saying
Yes.
it cannot just...
What I mean by that, it's not clear whether it was summary dismissal with a generous humanitarian gesture 10 days later, and that was the stand how it started. Then at the end of the trial, the stand was, this is not summary dismissal because we actually paid severance allowance at the normal rate. That was at the end of the trial. And by the time they came to the Supreme Court, it was back to, this is humanitarian. And before the board, I must confess that I'm not quite sure what it is now, because it's either back to the initial pleadings, it is summary dismissal with a humanitarian payment as found by the president, or it is something totally new, which is now there is a gratuity which encompasses notice. So that is why I'm saying, with all due respect, that UDL is unable to describe what it did. Had the president properly directed her mind to the requirement of section 22(1)b, she could not have come to any other conclusion than the one reached by the Supreme Court, namely that UDL has failed to establish that it could not in good faith take any other course than to summarily dismiss.
We were shown a contemporary letter in which the severance allowance is sent,
Yes.
stating that their view was that there had been sufficient misconduct to justify dismissal, but this was being sent ex gratia.
Well,
Why can't that be an explanation?
it is. The letter actually says two things, milady. It says that we are paying severance allowance because of our years of service.
Yes.
And then that it is also a humanitarian gesture.
We have to read the letter as a whole. don't we?
Yes? And
644, possibly?
Or, I refer to my letter of 21st February 2007, which in accordance with your request was remitted to Mrs. Ajiwa, your attorney. The management has further considered your case. Now, I would like to stop here. There is a dismissal when management further considers the case and has, in the light of your long years of service with the above company, and also in a gesture of goodwill. And so there are two things acting on the mind of the employer after it considered the dismissal.
Well, there are two different things. One is because you have been a long-standing employee, brackets, without prejudice to misconduct, close brackets, and because we wish to be seen to be doing the right thing.
Yes.
As reputational damage, as it might be in view. And then they carry on, as you're going to read us.
Yeah. A gesture of goodwill decided to pay you severance allowance at the normal rate in the sum of 1.1 million. and this notwithstanding that in your management you have been guilty of gross misconduct. Milady, what I wanted to say was this. An employer, and thus I believe that I will go in that a bit more later on about the principle, but an employer who is dismissing an employee on the ground of misconduct always has to comply with Section 32, or always had to. That is our old law, always had to comply with Section 32. What is clear is that the kind of dismissal which is envisaged by our law, Section 32(1)b, is one which deprives someone, when read with Section 35(1), is one which deprives the employee of everything. No notice, no severance allowance. In that sense, it could be said that Section 32(1)b envisaged only faute-lourde, gross misconduct.
But the employer is not bound to pay anything if he is able to establish faute-lourde, but if he wishes to pay something, why should the law prevent him or say that he somehow prejudiced his position?
For me, there is a distinction is as follows. You must, when you are employer, justify what you did. And there is a distinction between summary dismissal and dismissal on payment of notice and severance allowance. It is the gravity of the situation. Now, in France, it is said that faute-lourde implies an intention de nuire, which is like the intent to harm your employer. Yes. And that is why you are deprived of everything else.
It's one form of fault.
One form of fault. Whereas faute sérieuse, although it does justify dismissal, as opposed to a warning or whatnot, although it justifies dismissal because it is serious, it is not as grave as to justify depriving someone of everything.
But that's fact-dependent. You can have it grave incompetence, gross incompetence. I think that's mentioned somewhere else by the learned judge, the magistrate. That is also a form of fault.
Yes. For example, une faute professionnelle lourde, I'm tempted to say an accountant who cannot count, that would probably go into that category, or a lawyer who cannot read. But yes, there are faute-lourde, whatever, but the test is it so serious that when considering everything else, terms of service, your fantastic record, whatever the circumstances, I, as employer, has no choice.
And it includes considering the damage to the company.
Indeed. Indeed.
Or other employer.
And I would like to say this in this case. UDL make a lot of having had to enter proceedings to recover the overpayment. So it's not only the fact that prejudice was caused, but also that Michel Rivalan, or late Michel Rivalan, because he's no longer of this world, did not agree to repay what UDL considers to be a overpayment. Now, I would like to pause here because there's something that my ladies and your lordships would not have guessed reading from the judgment of the president, is that there was a concession on the part of Mr. Rivalan, of Mr. de Spéville. Indeed, he said, I made mistakes. He did not try to justify it. He accepted that mistakes were made in the computation, but he said, I did not make mistake only in favor of Mr. Michel Rivalan. I also made mistake in favor of UDL. And in fact, this is something that UDL picks on when they submit, because they think that adds insult to injury. And they say, not only does he make a mistake, but he actually helps Mr. Michel Rivalan establishing that there were mistakes in the other way as well. Why do I say this, milady? Because the charge was that there was a prejudice of 7.6 million. As Lord Wilson rightly pointed out, most of it relates to the extra payment. and that depends on an issue of interpretation. Should we have calculated it on salary or remuneration? And here I would like to pose to say that something which for me is striking is that both the magistrate and UDL said this: had Mr. Spéville looked at the board resolution, he would have known that he could not base himself on remuneration. And at the risk of appearing naive, I'm just asking the question, why would he know that? Because as we see, the board resolution talks of 1 year per année de service, 1 year per years of service, without saying whether it is salary, remuneration, or earnings, and then the equivalent of 1 year salary. Now, I say salary as a translation for the word salaire. In French, salaire is not basic salary. In French, basic salary is salaire de base. So,
Salaire
de base.
de base.
De base.
Well,
And that exactly is the evidence of Mr. Jean Piat, a senior member of the motion bar. I believe late Mr. Jean Piat. He is no longer with us. And Mr. Jean Piat says exactly this. When I said salaire, I meant earnings. If I wanted to say basic salary, I would have said salaire de base.
Sorry, this is 664 again, wasn't it? For the resolution.
Yes. And the evidence of Mr. Piat?
No,
Yes, and I'm just looking at the text of the resolution for salary.
665, I think.
645.
45, is it?
645 says, une somme équivalente à une année de salaire. And you will see that salaire is a pluriel. Take S. Now, if we look at the bundle of authorities, if I may take, because I must say that and this is the main point of the magistrate. She says, had he done his duty of verifying the resolution, he would have known that he could not pay remuneration. He would have known it was basic salary. And I beg to disagree. If we look at what Dr. Foucan had to say on the subject, and my ladies and my lords will note that the magistrate has no problem relying on Dr. Foucan when it comes to misconduct, it appears that she did not pay attention to what Mr. Foucan had to say on salaire. It is tab 19.
Sorry, what page are you on?
It's at tab 19.
Yes, I'm using the...
Oh, sorry. 1488.
Thank you.
Section 4, le salaire. I'm just going to draw attention to footnote 6. Il est à remarquer que dans les cas des employés dont le salaire de base est prescrit par un AE, le salaire de référence utilisé pour calculer le réajustement prévu par les Additional Remuneration Acts est ce salaire de base et non le salaire actuellement perçu par l'employé. In our law, which is greatly inspired by French, salaire does not mean basic salary. And one is at a loss to understand why a learned magistrate of an industrial court would prefer, on that account, the evidence of Mr. Iralal to that of Mr. Jean Piat. Mr. Iralal is an accountant. We won't hold that against him, but he is not a lawyer. Mr. Jean Piat is a lawyer of experience, appeared before the court, and said what he understood to be salaire. And yet we have the magistrate saying, had he read the resolution, he was bound to have known that he could not calculate whatever was to be paid on the basis of remuneration.
Can you said it was the plural, the salaire. The plural, you said.
Salaire.
You remarked on it being salaire.
Les salaires.
And is there a particular significance of it being les salaires?
I don't think it's like, as you will see in Faucan,
Yeah.
the title is Le Salaire. What I'm saying is that le salaire is usually, even le salaire means everything you earn, and not just the salaire de base.
But you might say that les salaires sounds even more.
Even, it's just, that's what I wanted to stress. It's just
A
not,
for sure, right? Yes.
yeah, it's just not this, the basic salary. And we see at page 1489, second paragraph, à la notion de salaire, certains préfèrent utiliser celle de rémunération, qui englobe non seulement le salaire principal, qu'on appelle encore le salaire de base, mais également les éléments accessoires du salaire, du complément de salaire. So, if I may stress on that issue, what the President considered so grave that could not be excused was a failure to consult the board minutes. And my humble submission to the board is that Mr. de Spéville actually says it in evidence. Had I seen the board minute, I would still have calculated it on the basis of what the chairman told me. What else I want to add is that there is no evidence at all as regards the source of that duty of an accountant. Now, there is no evidence that the accountant was also an officer of the company for the purpose of the Companies Act. As an accountant, Mr. de Spéville did not have access to the board deliberations, which are confidential. Under Mauritian law, we have what we call the Code of Corporate Governance, which applies to companies which are listed, like UDL, and the role of the board is clearly determined. And in Mauritian law, the chairman is the spokesperson for the board. Can we imagine a situation where an employer is called in a boardroom, sat down with the chairman of a board and the chairman of a corporate governance, and given instructions? The word information was used before. He was not informed. He was instructed to calculate the payment to be paid to Mr. Michel Rivalan. He was instructed in clear terms. Calculate it on the basis of everything which was paid to him in the last year. And we expect this employee to say, oh, sorry, can I please see the board resolution before I decide whether your instructions are correct? Even if that is the case, my ladies and my lord, there is certainly no evidence on record to suggest. I now propose to move to the second point.
Just before you do, can you help me? The same question that I asked of the other side about Mr. Hiralal and what he would have treated salaire as meaning from the...
Okay. Mr. Hiralal actually is a perfect gentleman who was very neutral in his approach. The most important thing that he said, that he understood the phrase, and I'm just going to make sure I read the phrase correctly. He understood the phrase, un ex gratia paiement d'un mois par année de service, to mean 1 month earnings. So, from naught, un mois, he understood earnings. And I had him accept that he had this reflex because under Mauritian law, when we talk about compensation, we don't base compensation on basic salary, we base compensation on remuneration. And then he says, but when he read une somme équivalente à une année de salaire, he understood it to mean basic salary. That was his understanding, my lady. Not that there is any text of law or any doctrine which contradicts what Dr. Foucan says.
So where does the question of whether it's in the written contract come into it? Because there was some debate about how it translated into practice, how much money was actually...
I believe this relates to more of a management fees. There was a debate as to whether the Board of Corporate Governance had decided to pay the whole of a management fee payable under a contract to Mr. Rivalan, or whether he was only entitled to 100,000 rupees per month. Yes. So, if I may now go to the operative reason for the dismissal of Mr. de Spéville. The case of appellant, paragraph 3, page 1211, we read, line 3, UDL's case has constantly been that Mr. de Spéville breached his duties as an accountant by inter alia grossly miscalculating the pension benefits which were payable to Mr. Michel Rivalan, the outgoing managing director of UDL, resulting in a significant loss of 7 million, approximately 7 million. With due respect, consistency is the last word that comes to mind when one considers the case of the appellant generally and when it comes to the operative charge in particular. We have laid great stress in the case of a respondent on the shift in the UDL case. This is at page 1235 as from paragraph 9 of the case of a respondent. Before before this board, UDL claims that there has been no shift, that it was entitled to challenge at trial the explanation which Mr. de Spéville had given at the disciplinary committee. We say that Mr. de Spéville had a right to know before his dismissal that his explanations were not being accepted, that his explanations were being challenged. We say that UDL had the obligation of affording him a reasonable opportunity to meet that challenge at the disciplinary committee. UDL cannot escape the fact that it succeeded before the industrial court on the basis of a case of which Mr. de Spéville was not and could not have been reasonably aware at the time. Now, there is a concession on the part of my learned friend for the appellant before the Supreme Court that the issue did not arise at the disciplinary committee. In fact, there is a ruling of a learned magistrate when objection was taken at the time of trial. You will see at page 225.
So what precisely is this issue that you say wasn't before the committee?
So before the committee, the case was that you miscalculated, and the gist of the matter is that you base yourself on remuneration when the board said salaire. That was the case. And the answer to that, my lord, was simply, well, I did not base myself on the board resolution. I based myself on the verbal instructions of the chairman. And at the request of Mr. Iralal, during the audit, I sought confirmation in writing of what was the oral instruction. Now, I'm at a loss. How can my friend say that this is something which only arises at trial? So here is the person, he's charged with miscalculating. And the particulars of the charge is that you base yourself on remuneration when the board said salaire, assuming for 1 minute that salaire in French is something else but remuneration. But that was his answer to the district committee. I did not rely on the board resolution. I relied on the oral instructions. Now, if that explanation was not accepted, before dismissing him, should he not have been told, well, we don't accept that you can act on the word of the chairman. We put it to you that it was a breach of your duty not to verify the board resolution. That was never done. So, Mr. de Spéville, to answer your lordship directly, never had the opportunity before being dismissed of explaining why he did not verify the board minutes. And one can imagine many answers for that. One could be, well, I wouldn't dare ask for a confidential document when being given instruction by the chairman.
Well,
whatever else, I'm sorry.
But he was told that the sum had been miscalculated. He was told that the severance payment to Mr. Riverland had been miscalculated.
Yes.
So that was all in issue, and the disciplinary committee accepted that it had been.
Well, we don't have the findings of the disciplinary committee.
Well, the magistrate.
We know that the dismissal letter refers to the findings of the disciplinary committee. We don't have them.
But the magistrate must have had them.
But, no, she didn't, my lady. As a matter of practice, it is a recommendation.
Right.
But to answer my lady on the particular question, yes, and that is precisely my point. It was always you have miscalculated. And it was even more. You have miscalculated because you took remuneration when the board meant basic salary. That was the main reproach. And his answer to that reproach was, well, I did not base myself on the board resolution. I based myself on oral instructions. And I'm saying, if UDL is now telling the board that it was entitled to challenge that explanation, and I do not dispute that, then my point is that it ought to have been challenged at the disciplinary committee. Mr. de Spéville ought to have been given the opportunity before his dismissal to explain why he did not consult the board minutes.
But he had the opportunity of dealing with the charge.
Yes.
In this procedure. So he went along to the disciplinary committee knowing that there was an allegation against him of a miscalculation.
Yes.
So he could give his explanation of how he had arrived at the figure that he paid.
And he did. He did exactly that.
Well, then it's a short point, isn't it, that the disciplinary committee did not accept that that was a proper explanation.
Again, milady, we only have the word of the employer as to what the disciplinary committee found. And you will note that one of the points taken before the Supreme Court is that the dismissal letter does not give any reason. It only says the charges has been found proved and you're guilty of gross misconduct. But my point I'm trying to make, milady, it is precisely because he was asked, how did you calculate? And his answer was, well, I base myself on the verbal instructions of the chairman. Now, if it was the case of UDL that he could not have done that it was a breach of duty to base yourself on verbal instruction of the chairman without asking to see the actual board resolution, surely that should have been the case put to him at the disciplinary committee.
Well,
And if you look at page 225, line 20, this is a ruling of a president upon objection being taken to UDL changing or adding to the case which Mr. de Spéville had to answer before the district committee. Line 20. The court is fully aware of the charges against the plaintiff and is alive to the fact that the plaintiff was never formally charged with having wrongly acted on the word of Mr. A. de Spéville and Piat, or that as an accountant he should have asked for the actual board resolution. However, the court believes that the defendant can put this question because one of the charge is that he wrongly computed the sum due to Mr. Rivalan. My point is, from wrongly computing, and that is the charge, from wrongly computing, on the basis that the board decided that you should take basic salary and you in fact took remuneration. That was the charge. You wrongly miscalculated, and the particulars was you should have taken basic salary as resolved by the board and not remuneration. And his answer to that is that I did not rely on the board resolution.
Yes, but this all turns then on what is meant by wrongly computed in the terms of charge 1.
Yes.
But you can wrongly compute something, it may be said, if either you get the addition or subtraction wrong, or if you take into account a sum which is greater than that which you ought to be taking into account. Because as an accountant, you're not just counting up, you are actually only dealing with sums which ought to be paid on behalf of the company. It's a position of great trust.
Yes. And in fact, if I may respond to that, milady, before the district committee, at least when the charge was clear, it was first, you took 13 instead of 12 months. That was one thing. You counted a payback as remuneration when it was a payback. You took into account benefits paid, but which was not accounted for in the statement of emoluments. And then, the big question, the big challenge, you base yourself on remuneration when the board said basic salary. To that I have two response. First, the board said salaire, and it is not the same thing as basic salary. And two, and most importantly, the response of Mr. de Spéville before the committee was, well, I did not consult the board resolution. And that is why he produced document AP to confirm the the oral instructions. And what is more, milady, is that at trial, another twist was put on that charge. He was accused of having relied on fake instructions. And there was a charge that Mr. Piat and de Spéville had prepared a letter de convenance to help him. So from a mere mistake, now we have dishonesty. Surely, that is the charge which should have been put to him, because that is the charge on which the magistrate found that the dismissal was justified. And I quoted in the case for the respondent the paragraph where it's clear for her, but she made it clear that in her mind, the fact that he did not deem it fit to verify the board resolution was what was unforgivable.
Well, that's a question of competence. What would a reasonable accountant do, knowing that there was an authoritative text and that he was being given purely oral instructions? So what would he do to verify the payment?
Related to that, if the question is, could Mr. de Spéville, if he was minded to, demand to see the board resolution. What right did Mr. de Spéville have as an accountant?
No, it's a question of what he should have done as an accountant, because he will have to write into the books and papers of the company the source which he used as the basis for making a very substantial payment, so that when the auditors come in, they can see where the audit trail is.
Yeah.
So he should make a note in the books and accounts where that trail is to be found. So he would naturally go to documentary evidence.
What we have in this case, milady, is clearly what did happen. Mr. Iralal did come. Mr. Iralal did ask for papers because there was none, and then came charge the document AP. My point is, whatever Mr. de Spéville should have done as a prudent accountant was not the charge.
Well, I think it was.
Well, we've got to 1 o'clock. In fact, we're past it on that clock, but we're exactly at it on the clock which I go by. And so we're going to adjourn now and look forward to hearing from you further at 2 o'clock. How much more time do you think you're going to need?
15 to 30 minutes.
Okay. Thank you very much indeed. Thank you.